Court is calling 2023 CR 3412B, State of Texas versus Mr. Sierra. How do you pronounce your first name? Eliza. State of Texas versus Eliza Sierra.
Hold up, this is already getting messy. The defendant is contradicting himself right out of the gate. That kind of confusion in court, it does not just look bad, it can seriously damage credibility. So here is the real question. Is he nervous or hiding something?
Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Humberto Saldana for Mr. Sierra.
And are you Mr. Sierra?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Sierra, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? And did you sign it? Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
On both counts?
Yes, Your Well, I believe the first count is with intent to deliver, and the second count is just mere possession. So we're proceeding for the judge.
All right, State, are you proceeding on count one, waiving count two?
Yes, Judge.
Any objection?
No objection.
All right, Mr. Sierra, I'm showing you what's entitled court's admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand your charge of possession with?
This right here is the moment most people underestimate. The judge is laying out the true weight of the charge of first-degree felony. We are talking 5 to 99 years or even life. This is not just paperwork. This is life-altering. Would you still plead the same way knowing that?
The intent to deliver controlled substance, penalty group 1, 4 grams to 200 grams. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Sierra, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to.
Now this is where it gets strategic. The plea deal sounds like a win. Reduced exposure, community supervision, but do not get it twisted. The court is not bound to follow it. So the question is he taking a smart deal or gambling with his future?
Jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on count 1. They're asking that your punishment be assessed at 8 years in the prison. There's a $500 fine. State recommends community supervision. There's to be judgment satisfied entered in county court for cause number 699061. You are to agree to have the weapon destroyed. And there's to be no possession of firearms while on community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 8 years and there be a TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged in count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Your Honor, I submit State's Exhibit 1 in the attachments.
No.
Any objections?
No.
All right, state, you may continue to confer.
Thank you.
Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, he is going to work once out there. He says that he.
And here comes the judge switching gears from legal procedure to personal accountability. This is where defendants either gain sympathy or completely lose the court. Let us see which way this goes.
Is looking to get this all behind him. And he is asking for intensive outpatient treatment if possible, because he works so many hours. I know that the TAP will show that up, Your Honor. I just wanted to add that.
All right. So what do you do other than have cocaine and meth?
I do framing and construction cleaning.
Mm-hmm.
And I have a business, a clothing business that I'm trying to get off the ground.
Mm-hmm. And you're just doing drugs on the side part-time?
No, just being foolish, Your Honor.
How old are you?
I'm 31.
I mean, how many years are we going to take this foolishness with us?
That's and everything happens for a reason. And being here incarcerated, you know, I've never really read the Bible and stuff like that. And I found that light in me now, you know, and I wake up more happy and everything now, you know. I'm ready to just take my life, you know, serious.
Yeah, what's your favorite verse in the Bible?
The Lord is my shepherd.
Oh, okay. Yeah, what verse is that?
It's Matthew.
What verse is that?
That's Psalms 23.
Okay.
I'm sorry.
No problem.
It's my first time like really getting into it, you know.
Oh, no. I'm happy. Sometimes, you know, people will always say that people find Jesus at the jail.
Yeah.
Sometimes they do. Sometimes they pretend like they're doing. But I'm always interested.
Yeah.
For me, whatever helps people get through this journey we call life,
Yes.
that's a good thing.
I got 3.
Wait, did you catch that we are circling right back to the same contradiction from the beginning? This is a huge red flag in court. Inconsistency is not just confusing, it can completely destroy your defense. So why is he doubling down?
Daughters and
Oh, what are their ages?
6, 7, and 8.
And who do they live with?
With both me and my girlfriend,
And who's your girlfriend?
Emily Colleen.
What were you doing with Samantha then?
That's my cousin.
So you and Samantha Servin were out with
No,
drugs.
I wasn't out with,
I'm sorry, what?
I wasn't out with nobody.
What? What is he saying?
He's saying that he was not present with anybody at the time of the arrest.
No, you were in the vehicle. What is he talking about?
That is his cousin that is mentioned in there.
All right. Is something wrong with him?
No, Your Honor. I believe that that's the only aspect that he sort of maintained was not accurate on the report. But he says everything else is accurate.
So you were not in the vehicle?
I was in the vehicle, but there's nobody with me.
Oh, so you're saying Samantha wasn't in the car with you?
I was by myself in that car.
No, they have S1 and S2.
Your Honor.
It says, based on my observations during my surveillance of the listed location and results of the traffic stop, we were able to detain S2, who was the subject of our investigations. We encountered S2's small children occupying several bedrooms of the home. Okay.
I was just drunk, I guess.
No problem. I understand. I'm going to need a PSI report on this. Ms. Ferguson, when can we come back? I need a TAP evaluation.
And I know it's a little unorthodox to ask, but would the defendant be eligible for a PR bond under the circumstances that he's already pled?
No, we'll see about a TAP evaluation, and maybe we can get the TAP evaluation done quickly. Will it take long to have a TAP evaluation? Okay. Oh, thank you. So, Ms. Fergus, can we recall this back in 2 weeks?
Yes, ma'am.
And I'm just asking for a TAP evaluation so I can get an idea of what's going on.
Yes, Your Honor.
If you have them come back on July 17th.
All right, so we're going to be back on July 17th. Mr. Sierra, you need to be very honest with what you tell them in the TAP evaluation because there's something going on here I'm not able to figure out because I don't have enough information yet. So make sure you're honest with them, okay?
Yes, ma'am.
All right, thank you.
Thank you, Your Honor.
Thank you. Court is calling 2023 CR 1012, State of Texas versus Guadalupe Gutierrez. Can I have parties approach and announce for the record for the state?
Daniel S. Clark with State of Texas.
Defense?
Lorraine Efron.
And are you Mr. Gutierrez?
Yes, sir.
All right, you entered a plea of deadly conduct with a firearm as a third-degree felony. According to the plea bargain agreement, punishment is to be assessed at a cap of 10 years. The state is remaining silent on your application, and then there are no contact orders. Have both parties had a chance to review the PSI report, state?
Yes, sir.
Defense?
Yes.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
All right, the state is silent. Defense, do you have any witnesses?
Just, if I may, I have a couple of paycheck stubs or 3 paycheck stubs of my clients that I'd like to offer. And I had given the state an opportunity to review them. And then I have some photographs of my client with his daughter, if I may offer those to the court for your consideration.
Yes.
I also have a letter from his boss, Judge. I need to find that. I'm looking for that letter from his boss, Judge. I
All right, if there's no objection from the state, if you want to make a proffer of what the letter says, I do believe he's employed.
Yes, Your Honor.
You can look at this as a
It
matter of
just,
public
it
record.
speaks to his promptness as an employee, as a valuable employee, and as to him being consistently employed and being able to continue to be employed should the court grant this application. This speaks to how much the employer values him as an employee, Judge. Mr. Gutierrez, on his behalf, Judge, has had a lot of time to reflect during the pendency of this case. He has 3 children, including a daughter whose picture I showed you, his biological daughter. And he has recently reconnected with her and reestablished good communication with her mom and with her. And he feels extremely motivated now between the opportunity he has at work to do well and his relationship with his daughter being very positive. And he wants to be able to continue in that path and show the court that he can do better. I see the PSI recommends intensive outpatient. I think their focus is probably alcohol. And if the court were to deem any other conditions free, he would absolutely comply with whatever conditions the court would deem appropriate. He has been on GPS for a considerable amount of time while this case was pending. I think maybe since
So it's been a year or 2 months.
a year and 2 months, he's been on GPS with no violations. And I think that speaks to his motivation to do better and his respect for the court orders and his ability to be a successful probationer.
Now we shift to a completely different case, but the stakes just as serious, and listen closely. The judge is about to break down a mindset that gets a lot of people locked up. This is not just about the law, it is about decisions in heated moments.
And I hope the court will take into account, that's a significant amount of time. He was on full GPS house arrest, and then that converted to partial, where he's been able to work, but no violations. And so we're hoping the court will give him an opportunity to show the court that he can be successful on probation.
All right, but here's my concern and what I don't understand. How old are you?
37.
You're 37. I don't understand going to a bar and people tell you to leave. And your answer to people telling you to leave is, I'm going back to my vehicle and I'm getting a gun and firing the gun. I don't understand that. So I don't know if he wants to be under oath to explain that to the court, but this is what I'm trying to wrap my head around. I don't understand why people's first answer to any situation is, let me go get my gun.
Well,
And I know people, I don't know, people seem to have a love affair with weapons. And if you want to have a love affair with the weapon, then you need to treat the weapon with respect, because the weapon can kill if it's in the wrong hands. And I'm just trying to figure out, there's a incident that happens. Somebody calls you out your name. Oh, let me go get my gun. I'll show you who I am. Somebody tells you to leave a bar because, I don't know, maybe you're intoxicated. Maybe there's some altercation. I don't understand why people don't leave.
I would say that the offense report and PSI reflect that he says he had had 5 beers and 3 shots. So I would submit to the court that he was not thinking.
Yeah, I mean,
He
to
was,
me,
and I'm not saying that intoxication is a defense or mitigating at all. I'm just saying that, it causes a loss of impulse control. And
I mean, I understand what you're saying, counsel, but sometimes I think alcohol gives people courage to do what they otherwise wouldn't have done, as opposed to, oh, my inhibitions are released. Yeah. So I don't know if he wants to speak to the court or not, because I'll tell you, I'm leaning towards sending you to prison. I haven't heard anything that would suggest to me that I shouldn't send you to prison, because I don't know somebody who takes some shots. I realize you were intoxicated. I'm reading it, but people put you out of the bar. And it's on Mother's Day too.
It was 6 guys that took me out.
Yeah,
So
because you wouldn't leave. When people tell you to leave an establishment, just leave. So I don't understand why I should give him deferred adjudication when he went to a bar, and according to things he's saying, somebody tried to come on to his fiance. That's when you leave. And they told him to leave, and maybe they were very rough and pushing him out of the bar. I will give you that. They were rough. They bruise you up, maybe push you out of the bar. But that's where you leave and go home. Hopefully you were not driving with those tequila shots. And then, or if you don't want to leave and you stay in the parking lot, you call the police, but you don't tell people, well, I'm going to show you who I am. And then you go to your vehicle and get your gun. Did your fiance say any, did his fiance say, hey, what are you doing? This is crazy. Let's just go home.
I don't know if that's-
Oh, okay.
The altercation at the bar wasn't good. I think that there were probably others there who also had weapons. Again, not to say that there's necessarily a defensive or mitigate, but maybe it's a little mitigating. It just turned out to be a very rough circumstance. I'm not making light of the offense because obviously it's serious. And I think that the PSI speaks to the alcohol being an issue and intensive outpatient. So I think if the court would give him some opportunity to address the alcohol and maybe perhaps anger management issues, maybe that would help to lessen his future risk to the
And I
community.
see that there are other people who had guns, because I see Eric Fields, who's one of the complainants, not the main complainant. He says, I just want my gun back.
Yeah.
This is Texas. We just want our gun back.
So, ma'am, I haven't been in trouble since 2005, and being at that
You want to
bar,
raise your right hand to be sworn in? Can you, do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Guadalupe Gutierrez,
Right. And let me just tell you, your statement about you haven't been in trouble since what time?
2005.
I haven't been in trouble since 1969, and I'm putting it at 1969 because I was potty trained by then. And I didn't pick up any criminal cases. I always tell people when they tell me, I haven't been in a gang, I don't do drugs, I haven't been in trouble. It's like, do you want a cookie for that? That's what you're supposed to do. So let's not start with, I haven't been in trouble since this date, because I'm looking at your criminal history and one of them is terroristic threat. And then criminal trespass. And is this criminal trespass with a weapon?
That was with a box cutter at my aunt's bar. I just left work.
Okay. And then the theft of a vehicle.
That was back in '04.
Yeah. And now we're back here.
Yes,
And on on the probation from 2013 on the criminal trespass with a weapon, your probation had to be extended. Then on the theft case, a motion to revoke was filed and you were sent to TDC. And now you have this that started as an aggravated assault with a deadly weapon, and the state reduced it to a deadly conduct third degree. So speak to me. Why should I give you deferred? I don't understand why I should.
well, man, I'm not a good talker, but
That's
you
okay.
told me not to say how to start it, but
No,
I
go.
was trying to prove a point that since 2005, I haven't been in trouble, you know, and all those years I was in the oil field for 15 years and I've never had my daughter. So now that I got my daughter, it's a blessing to me because I always wanted it. So now I have an opportunity to be a father and I don't want to mess that up.
I mean, but you have.
I understand.
I think the reunification, if you will, sort of took place after this offense. Is that correct? Meanwhile, you've been on probation with your daughter.
Yeah, it's been good. It's just like I've been on the monitor and I can't blame nobody else but me. But it gets me kind of angry because I can't take my daughter out other than be with her in the living room.
Well, I don't know why you angry about that. That's all on you.
That's what I just said.
If you would not go to a bar drinking to the point of intoxication and you're in your 30s, you're not a teenager who doesn't know better.
I think that if the court would give him an opportunity for some form of treatment, I think he would welcome that and appreciate that opportunity.
I just don't think he's a good candidate for probation. I mean, shooting up a bar, and it wasn't.
It was outside in the parking lot.
And State, I know you're silent.
Yes, Judge.
Is our applications for probation, for community supervision and deferred?
Yes.
I don't know if it makes a difference to the court. I don't think it necessarily does, but we can withdraw the deferred.
Now, see, this is what I'm reading, and this is my problem. I can understand people being angry and getting upset with people. I honestly don't ever understand people pulling a weapon, because I always taught if you're going to pull a gun on somebody, you need to know that to kill somebody, and don't pull a gun unless you're going to use it. That's what I was always taught. But what it says here in the police report that you stipulated to, I contacted Jason, who is the manager and point of contact for surveillance. Jason provided me with footage from one of the cameras. Jason said he was working on getting footage from the other cameras as well. The footage showed Guadalupe, that's you, being taken out of the bar. He walks to his car and pulls out a small handgun. Guadalupe pointed the gun in the air where 4 spent shell casings were found. Guadalupe and Melissa got into the vehicle and he pulls up to the curb. Eric can be seen in the corner near a white car. Guadalupe opens the car door and his hand extends out. Guadalupe then lowers his hand with the gun and points it toward Eric.
I never pointed the gun at anybody.
I mean, that's what they say is on the video. I mean, this is video. This is not.
And I showed her that when I saw the video, I pointed it.
Well, because it's surveillance, some parts of it are a little clearer than others, but as the car drives out, it's a little bit less clear because of the angle of the camera.
Okay. All right. Is there anything else from either side?
Nothing to say, Judge.
No, Your Honor.
All right, how old is your daughter?
7.
Okay. All right, this is what the court is going to do. The court is going to find you guilty, sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with Eric Fields and Lefty's Draft House. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, and because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission.
And this is the moment everything lands. After all the arguments, explanations, and second chances, the judge makes the call: 3 years in prison. So ask yourself, was this outcome inevitable, or could it have been avoided with just one different decision?
To appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. I did take into consideration that you have a child and that you want to be in her life and do better, but you're going to have to start making better decisions. And it's obvious that you can't drink alcohol at all. So no alcohol, you understand? All right, good luck to you.